109. Counsel, would you like any rebuttal time?
Yes, 2 minutes.
2 minutes. Go ahead.
May it please the Court. My name is David Kaplan. I'm representing Appellant Howard Wright in this matter. In this case, Howard Wright was convicted of second-degree murder. The people's case against him was based almost solely on Y chromosome DNA testing. However, Y chromosome DNA testing only is useful for excluding individuals, and if individuals are not excluded, there's no statistical significance to not excluding individuals.
Didn't that come out during the cross of the people's expert? Wasn't that information available to the jury when it was rendering its verdict? When it was deliberating? Had all that circumstantial evidence, the witnesses, and then the cross of the people's expert?
Yes. In turn, the expert for the people did testify that she couldn't identify the actual Y chromosome DNA of Howard Wright, yes. Did that answer your question?
Yes, it answered my question. It then seems to me the next question is then why isn't there enough evidence before the jury? They already know that there's a weakness in this particular science-based evidence.
Because Howard Wright's DNA was never identified on the victim or the crime scene.
But there was other circumstantial evidence in the case, right?
The only other circumstantial evidence was the testimony of Evans, Keith Evans, and Mildred Anderson. Keith Evans' testimony was that he observed Howard Wright well before the time of death. The time of death was estimated to be between 11:30 p.m. and 3:30 a.m. from November 28th to November 29th of 1995. Keith Evans testified that he saw the victim and Howard Wright together at somewhere before 8 p.m. on November 28th, which was at least 3.5 hours before the time frame of death.
All right, so the jury's got evidence about people who see him before, see the defendant with her, the victim beforehand, don't after the time they don't see her, they see him with the car, and then they've got this evidence related to the Y chromosomes and the DNA, and defense counsel crosses the expert on that, so the jury hears the weaknesses related, the weaknesses and the limits related to the DNA. Why isn't that enough to support the verdict?
Because the Y chromosome DNA did not connect Howard Wright.
But it didn't exclude him, did it?
It didn't exclude him, but I mean, if you had...
That's what the jury heard.
But not excluding him had no statistical significance.
So they could take it for what it's worth, because defense counsel had crossed their expert on that very issue.
It did exclude some people, right? It did exclude some potential suspects.
Yeah, but the only people that were excluded were people that were in the reference sample, which was very tiny. They brought out in cross-examination that there could have been many people in the courtroom that had the same DNA profile.
So, counsel, isn't it your point that defense counsel failed to object to statements in summation and possibly in opening statements that Mr. Wright's DNA was found on the ligature and in the panties of this victim?
That was that's our second issue, that there was ineffective assistance of counsel because his failure to object to prosecutorial misconduct. The DA equated Y chromosome DNA testing to traditional autosomal testing, where you can determine to a high probability the identity of an actual person's DNA. Here, you have Y chromosome DNA, which could have been it was impossible to determine that this was a specific person's DNA, Howard Wright's DNA or anybody else's Y chromosome DNA. So the fact that the DA repeated over and over again that it was actually Howard Wright's DNA was highly prejudicial to my client.
Which DNA, what was so prejudicial? I mean, there was clearly some evidence that the defendant was with the victim at some time that night. So,
Right.
So the DNA that was, whether there was sexual contact or not, the DNA would confirm that indeed he was with her at some time. How does that point to him being responsible for her death?
The DNA did not confirm that he was with her. It never confirmed anything.
If taken the way the prosecutor presented it, that's what I'm saying. I'm looking at whether this was, ineffective assistance of counsel.
Oh, okay.
Okay.
Right.
And so my question is what is the tremendous significance of the prosecutor's comments? What would it establish if believed that there was no proof of?
If believed, it established that it was Howard Wright's actual DNA on the swabs from the victim.
Right, but we knew he was with her, so there was other proof that he was with her. So why, right?
Well, yeah, I mean, that's an additional point in his favor, that he was with her earlier in the evening.
Mm-hmm.
And
I thought
so,
he made some statement that he had oral sex with her.
Yeah, he did. So, yeah, I mean, he was with her, but it doesn't.
That statement's not just that he's with her, but that he's had some intimate physical contact with her.
But this doesn't, you can't infer from that he murdered her during the time frame
Correct.
of
The
death.
question is whether or not, as you're suggesting, the counsel was so ineffective given that you've got the circumstantial evidence that's presented to the jury and the opportunity by defense counsel to have cross-examined the people's expert witness related to the limitations of the DNA evidence.
But the Y chromosome DNA is substantially different from traditional autosomal DNA. And using the Y chromosome DNA, the DA inferred that that was Howard Wright's actual DNA. But
Are you referring to on the ligature that was used?
On the ligature.
Is that what we're concerned with? That's the point.
Yeah, on the ligature, on the hand ligature, on the panties ligature, on the vaginal swab, that it was, she stated over and over again that it was Howard Wright's actual DNA, and that was impossible to determine. Her own witness said that she could not determine that that was Howard Wright's DNA. I mean, it could have been any number of people. This woman, the victim.
Defense counsel also referenced the weaknesses and the limitations of the Y DNA evidence?
I don't know. I mean, he did some cross-examination in which that was brought out, yes.
Okay, counsel. Thanks. You'll have your rebuttal.
Good afternoon, Your Honor. It's Jeffrey Clark for the people.
Counsel, what about the summation? I mean, that's way overstated. You don't think it's ineffective counsel that not to object to that?
Certainly not.
Would you not object to that?
I think in this context I probably would not have objected.
Why would you not have?
Well, first of all, because there was no question that the jury understood what this DNA evidence did and didn't show. That was laid out from the beginning.
But the counsel, the prosecutor, is saying something that's just not the case.
Well, I wouldn't agree with that, but
what did he say that's true about that they found his DNA in this place and that place and the other place? What is true about that?
Well, I think, and I tried to lay this out in my brief, I think that's an argument about what all of the evidence shows. So when she's talking about the DNA, she said, you have to understand the DNA in the context of all the evidence. I think.
But she says very specifically.
Yeah,
that's an overstatement to be kind.
Okay.
Why would you not object to that?
A couple of reasons.
And I understand you don't object, but why would defense counsel?
But okay, if we decide that that's not an argument about what the totality of the evidence
let's
shows,
assume
it's just a misstatement.
Very prejudicial misstatement.
It's an overstatement of the evidence.
Yes.
For one thing, the DNA evidence was not the key to this crime, to this prosecution.
Isn't that the most significant evidence, or no?
I think the most significant evidence is the timeline combined with the physical evidence, the placement of the sock, so forth.
In your brief, you said that it was a circumstantial case, and I think you're right.
Absolutely.
if that's true, and then at the summation, the prosecutor says they thought they had gotten away with it, but they left their DNA all over the crime. She argued that the hair found on Daggett's vaginal area comes back to Christopher Gifford. She stated that when we examined the vaginal swab, there were 2 contributors, and the sperm fraction of the vaginal swab matched Y profile of the defendant and Gifford. Is there any doubt that all of that DNA belonged to the defendant in your mind?
I think the context makes it clear that that is the defendant's DNA. I think that's the argument. But
Kaplan makes the point. It doesn't. I mean, all it says is that he might be part of 100,000 or 1 million people. She made it sound like there's only 2.
I mean, again, I think that's an argument about what the other evidence allows you to conclude about the DNA. But if you don't accept that, let's say that that's a misstatement, that's an overstatement of what the DNA shows. She has also just said what is indisputably true. This is evidence that shows simply you can't exclude someone, you can't quantify it. She lays all that out before she starts.
She said this is a case of common sense and science.
Right.
And then she says DNA.
Well, she starts out with the timeline and with the sock and so forth, the physical evidence, which I think is really the heart of this case. But with respect to that DNA evidence, let's say she's overstating what that shows. The jury is not going to misunderstand this. The defense has set it up from the get-go, from his opening statement. He said, remember, listen to that testimony carefully. What is that testimony actually going to show you when it says not excluded? It's not going to show you much of anything.
Yeah, so if it says it's not excluded and she says that the DNA comes back to Christopher Gifford, she's right.
So you object if you're afraid that the jury might actually misunderstand. Oh, despite all that testimony and so forth, I think the DNA.
The judge is saying it's not true.
And so, I mean, yeah, you could object to that, and the objection the result of the objection would be you get an instruction from the judge saying, remember, statements of attorneys.
I mean, the judge might come back very clearly and say, Ms. Dorley, if you do that once more, I'm going to grant a mistrial in this case because you damn well know that this is a Y chromosome and it's not definitive at all. So you cannot say that it's the defendant's DNA. I mean, it's not just. I mean, you were about to suggest that the judge was going to blow it off, which sometimes happens. But
I think what you get, I think you're likely to get a pretty rum-dum kind of instruction that's not going to do a lot more than what the defense has already done in his opening statement, in his cross-examination, in his recross of Clement, and in his summation. He's said this over and over again.
You think that outweighs the damage that could very conceivably be done by that kind of, whatever you want to call it, overstatement? I mean, sometimes there are errors, as we know from the law, that are just so egregious to let, if you were making an argument, to let you say the DNA of this defendant is all over the plaintiff, all over the complainant in this area, that area, the other area. Couldn't that be terribly, terribly prejudicial, so much that it's an egregious error not to object?
In context, something like that could certainly be. I think really the test ultimately is it for it to be misconduct or for it to be ineffective assistance to not object to misconduct in submission. I think it has to be a summation that would get you a mistrial if you object to it. I think if the defense objects here and asks for, and the judge sustains it, and even gives the...
Or a very strong reprimand.
Yes, gives a strong reprimand. He's still not going to get a mistrial because this statement did not deprive the defendant of a fair trial.
Some clarification for the jury. I mean, the letters DNA have meaning. They're compelling, especially when the prosecutor is saying this is about common sense and science, as Judge Pickett has already mentioned. Right? You're not just talking about, his hat was left at the scene. Maybe that has some meaning, too.
Right. Right.
Isn't there something particular about referring to the scientific, quote-unquote, objective evidence that's different? It's the one thing that connects this defendant, according to the people, to this actual crime as opposed to everyone else just sees him with her before and sees him with the car afterwards, and he's got his own statements that he's had oral sex with her?
Well, I certainly don't agree that the circumstantial proof outside of the DNA is not strong. I think it's very strong.
I'm not saying it is or isn't strong.
I understand.
But obviously, the people thought there was something really important about this DNA, even with their own expert on cross admitting the limits of that DNA.
Right, right. But I think that's the key, is that because I think it is true with scientific evidence that there are sort of special dangers about the jury potentially misconstruing. But all of that gets laid out very clearly in the opening statements, in the testimony.
But DNA in some ways is easily understandable today. People watch TV, they know the power of DNA. And to make such a bold statement is so damaging that isn't it, in your mind, possibly that outweighs everything else?
No, Judge, because the jurors still listen to the evidence. They've been instructed to listen to the evidence. They've been instructed that the arguments of counsel are not evidence. The evidence here was very clear about
this. The jury would say to themselves, yeah, the prosecutor said that his DNA was found all over the victim in all these different places. But
just inconsistent with the evidence we heard.
But we've heard the other evidence, so we'll just kind of zone that out. We know this is a special kind of DNA test. We know that it really wasn't found all over the victim, that they didn't eliminate him. So they're going to make all those very educated judgments instead of saying, wow, you know, that maybe we got it wrong. The DNA of the defendant was all over the victim.
Yeah, no, I think they're not going to do that because that wasn't the testimony, and because the defense attorney made sure that they understood that wasn't the testimony.
Well, let's assume for a minute that the summation was the defendant's DNA is inside her, on her underwear, on the ligature that binds her. What's the jury supposed to do with that?
Well, I mean, again, I guess I can't say enough that I think that the fact that the defense counsel makes this argument very clear and the fact that the testimony is very clear really limits that prejudice significantly. But if I can make one other separate point.
You can say that. Okay.
What?
Go ahead.
I beg your pardon, Your Honor.
Go ahead.
But if I can make one other point, which is the defense did not rest, it did not live or die on the DNA, just like the prosecution didn't live or die on the DNA. The defense makes this argument, and I think this is why Mr. Kaplan takes issue with the defense's opening statement. The defense is making a different argument. They're saying, you know, this isn't his, they're not going to be able to prove this is his DNA. Be careful about that testimony. But even if it is, because he's going to come in here, he's not going to contest that he had sexual relations with this woman that night. He cross-examines extensively about transference, about how you know, this is a small DNA sample. That's why you have to use the YSTR testing on it.
But to me, the linchpin is the ligature, because whether he was with her, whether he had sex with her, all of that, the jury could say, well, that doesn't really prove anything. But once you have that prosecutor saying his DNA was all over, it was on the ligature that tied her up. I mean, that's, you know, like end of game.
Well, but I think that's not the way the defense is presenting the case, and I think the defense has counter-arguments to that. And again, I'll go back to the fact that the jury hears the evidence. They don't just hear these isolated statements from the prosecutor. They hear the defense has made this very clear from the get-go.
Okay, counsel. Thanks, counsel. Counselor Rebuttal?
Yes, I'd just like to make another point on our insufficiency of evidence argument that the DNA evidence, the Y chromosome DNA evidence, coupled with the observations of the witnesses Evans and Mildred Anderson, were insufficient to convict my client. There was no evidence that he had any contact or access to the victim during the time frame of the period of death. The DNA, the Y chromosome DNA evidence didn't provide that. Evans' testimony didn't provide that. Anderson's testimony didn't provide that. In fact, they had only seen him with the victim over 3.5 hours prior to the time frame of death. And when he did see Evans during the time frame of death, it was on the street when they were talking, and they saw the car go down the street, the victim's car go down the street without being able to identify anyone in it, but the fact was that the car went down the street. So there's nothing that shows that my client had access to the victim at the time she died.
Okay, counsel. Thank you both. Appreciate it.